Okay, looks like we have a good group in. Thank you, everybody, for joining us tonight. It's a beautiful night to do a webinar on estate planning. My name is Andrea Krupp, and I am the Director of Planned and Estate Gifts at Providence College. I am a recovering attorney. I practiced for many years before I took a job at the Catholic Foundation for the Diocese of Providence. I served there for 10 years and am 1 year at Providence College. I love it here. I'm not a grad, but now I feel like part of the Friar family. So it's been a great, interesting year. Let me give you a quick overview of what's going to happen tonight and how we're going to run this webinar. We are going to introduce you to two couples that we're going to use as examples of folks that have different questions at different places in their lives. And that's how we're going to use the format. So for the first 20 minutes or so, we'll talk about a married couple. And then during the second half of the evening, we will talk about a widower with an extended family. We will take questions in the question and answer button down at the bottom of your screen. If you type in your questions at any time during the presentation, we will take those questions at the end. There's so much that we want to get through. We want to make sure you have the information throughout our 45 minutes of presentation, but we'll then at the end save 10 minutes to answer questions. If we don't get to all the questions during this evening's presentation, we will answer them in written format and send them to you by email. So within the next 2 days or so, you'll get a list of the questions and our answers if there are any that are still outstanding. Let's see, there will be a recording that will be available online within the next couple of days as well. That will be in the Friar Ties section of the Providence College website and also on the planned giving section of the Providence College website. So either one of those areas, you'll be able to listen to this again if you missed something or wanted to hear it at a later date. At the end of this evening, you will be given a link to a survey. If you would please fill that out, I'd really appreciate it. This is my very first webinar that I'm hosting. So please give as much feedback as you can. It would really help us to form the next sessions that we're hosting. Money Matters is the first, this is the first of the Money Matters series. There will be 4 different sessions. Tonight is the first one, 3 more, and there are descriptions of the remaining 3 on the Friar Ties section of the Providence College website as well. Let me introduce you to 2 panelists tonight that I am so honored to have met and am working with. These women are just amazing, and their bios are so long that I could not possibly do them justice with the little snippets that I'm going to give you tonight, but I'm going to try my best. Lydia Shekels earned her bachelor's degree at Providence College in 1975. She is a partner, CIO Emeritus, and Senior Financial Advisor of Westcott Financial Advisory Group, which is one of the first fee-only firms in the country. She is a certified financial planner, chartered life underwriter, chartered financial consultant. She serves on Westcott's Portfolio Strategy Group, which oversees the firm's investment strategies, ongoing due diligence of the investment managers, and asset allocation design. She is also a member of the investment and management committees. If you have ever sat in on any investment or management committee meetings, you will know that it takes a lot of perseverance and smarts to get through one of those. I have done it, and I get about halfway through before my eyes glaze over. So for that reason alone, she is a woman to admire. She is a very sought after featured speaker for many professional and civic organizations. She has a background in financial planning and investment management and practices mainly in the areas of insurance analysis and planning, tax and cash flow management, and estate planning. Lydia, thank you so much for being part of this evening. I'm really honored to have you here. The next person that we have tonight is Deb DiNardo. Deb is an attorney at Orson and Brusini in Providence. She received her JD from Syracuse University College of Law and her bachelor's degree from Providence College in 1978. She has an extensive experience in trust and estate administration, including many years within a major bank trust department. That's where Deb actually found her passion for estate and trust planning. Deb advises individual clients and multiple generations of families how to preserve and protect assets for their intended beneficiaries. Her important work includes reducing the transfer taxes between during life and after death, creating estate plans that avoid probate if that's appropriate, sophisticated planning techniques for complex estates, the creation and administration of special needs trusts for disabled individuals, and protecting elderly clients from financial abuse, theft, and fraud. Deb was a member of the Catholic Foundation of Rhode Island board. She was the chair for 9 of the 10 years that I was there, and was on the board for the Hattie Ide Chafee Home. She was on the board of directors for that. Deb, again, so nice to be back with you. We've spent many years together working, and I am truly blessed to have you as part of this group. So like I said, we're going to introduce you to 2 different families tonight. The first one is Jim and Jane Smith. And Lydia, why don't you get us started introducing us to this couple and how they came to your office and what kinds of things they're asking you about.
Thank you, Andrea. Yes, Jane is a graduate of PC and is in her late 60s. Jim is in his mid 70s and has fully retired. Jane is still working, plans to work until she's about age 70. So they've been coming to see me for a few years, but it's been a while since they had everything refreshed and updated. And this time we were more persistent in getting them to give us all the documents that we needed, including their property and casualty insurance and their documents, their estate documents. They have been philanthropic, but in small ways. They have no children. They don't have any close ties to family in terms of who they'd like to leave their estate to, which is one of the reasons why their wills are 20 years old and I haven't been able to get them to update them. They don't recall ever having healthcare power of attorney or living wills, but their primary focus was really on whether they have enough to live on, and also whether they can start giving some of their money away. Certainly it's important to Jane to support education. She'd like to make a gift to PC, and she's exploring different ways that she can do that. As part of our process, we did a cash flow projection going out beyond age 95, and they certainly look like they're financially independent and they can afford to start giving, particularly with some of the appreciated stock that Jane inherited. Not really inherited, but it was gifted to her from her grandmother. And so she has some very low basis stock as part of their investment account. They haven't tried anything of any note yet, just small gifts, some to PC, some to other entities. She wants to maximize their tax planning as best she can while she's still working. So now that you have a limit on state and local tax deductions, they have been itemizing their deductions every other year. And so they want to know whether there is a year before Jane retires that they could make a more substantial gift without compromising their financial security. And their only wild card out there is that they don't have long-term care insurance. They don't have family members who can be a support in the situation where they would need advanced care. And that's where their cash flow could be somewhat vulnerable. So it's premature for them to make a significant gift, but they can start to certainly explore ways to do more than what they have been. In reviewing their insurance, which was really important to us, we like to make sure that they're not leaving themselves open to lawsuits or claims, they did not have excess liability coverage. So that was one of the first recommendations we had to make there for them to make sure that it fit well with their auto and homeowners.
Lydia,
And
I'm going to stop you there just for 1 minute. Would you expand on that? So I know there are folks, as a general rule, you get life insurance, you get auto insurance, you get homeowners insurance. Why is that important at this stage in your 60s and 70s? Why would it be important for you to look at a liability insurance policy or something like that? Can you give a little more background on that?
sure, and I'm going to step back and say to your homeowners as well, because many people, once they pay off their mortgage, they try to save money sometimes on their homeowner's premium, and they let the replacement cost coverage slip, or they don't keep it insured enough to get them replacement costs. So you do need to make sure that your home is insured at replacement cost. And then your biggest liabilities can be your home, your auto to some degree if you're in an auto accident, but you think of the people who could come into your home, whether it's somebody who, cleans the house, does some yard work. People can slip and fall on your sidewalk. They can be hurt by a falling limb in your yard. If you have some trees that are starting to look less healthy, those become liabilities. You have a little ice, you have the mailman slip. People can sue you, and excess liability is recommended at least to cover your investment assets. You can't, unless you have multiple properties, boat, and a lot of other exposures. In this case, about $3 million of coverage would be perfectly appropriate. It sits on top of the liability limits for your homeowners and your auto insurance. So it's all seamless. Generally, you cannot buy a standalone excess liability policy. It would go with most likely your homeowner's policy. Company would want to have both for coordination. But it's important coverage. It's often overlooked, and it's not that expensive. So sometimes people will go with $5 million of coverage for peace of mind because it's not that incrementally more than $3 million. Okay, so what I've done is, I've suggested that they talk to Deb because they've got a couple of issues. One, on their estate documents, they're not even close to the people that they've nominated as executors and trustees. They don't know who to name. That's been a struggle for them. They really don't know who to even give healthcare powers to beyond each other. And they're in a quandary right now. They have heard about donor advised funds, and I have suggested that they look into a donor advised funds to gift that stock that Jane has at with very low cost basis. So it's not a cash flow item, but they could start this way and decide what tax year they'd like to get the benefit of that tax deduction, because that's the benefit of a donor advised fund, is that you can make the transfer in a given tax year, but you don't have to make the disbursements to the desired charities until future years. So it's whether we have enough time to get an account like that opened. But beyond that, they did ask about trusts, whether there are some charitable trusts that they might be able to pursue, and something that they might be able to add to over time. They don't necessarily need the income right now, but they'd like to learn more about having some retained interest in a trust. So overall, their investment portfolio is well diversified. We can always find a source of appreciated securities to make the gift rather than use cash, because we're looking to do some tax optimization here. So I think that they really need to sit down with Deb, and then together we can motivate them to keep this process going. I mean, sometimes it's taken me years to get a client to finally get new documents executed. And I think in this environment with COVID, people are being much more motivated to dust off those old documents and say, well, maybe we better get at least something together. So I'm
So
just
Deb,
gonna,
we've got Lydia who sat down with Jim and Jane, and she sent them to you, and they've got, you know, enough assets right now that seems like it'll carry them through, with the caveat that they don't have health insurance, they don't have long-term care policy. So you've got a couple in front of you that has very old estate documents, and not really sure that the people that they've elected to be the trustee or executor of their whichever documents they have in place, a will or a trust, are the people that they really do want. What kind of conversation are you going to have with them now that they're sitting in front of you?
Yes, Andrea, and as Lydia indicated, it really is a team effort, right? So these folks are clients of Lydia's. They're also clients of mine. They're not new. So it could be a new relationship, right, where they've met with Lydia first. They don't have any estate planning, or they know they have to have an estate plan or update their estate plan, and maybe their attorney retired, or, you know, so it's sometimes it's a new situation, a new engagement. In this particular instance, we've worked together before, and just the concept of everybody working together, all of your financial advisors, whether it's Lydia or me, you have an accountant perhaps as well, but getting everybody on the same page is really in your best interest at the end of the day, because we do help each other and coordinate with each other. And that is certainly what I know Lydia and I always recommend to clients from the get-go. And as Lydia explained, these folks have an estate plan that's 20 years old. They have wills, no trusts. They have powers of attorney for financial matters, but no healthcare power of attorney, as Lydia said. So I think one of the things that I start with is enforcing a couple of concepts, which Lydia also expressed and otherwise alluded to. And this concept of having a 20-year-old financial power of attorney, right? So technically in the law in general, there's no such thing as a stale or too old financial power of attorney. But the problem is not necessarily with the law, but what the third party to whom the power of attorney is presented, how they react, right? So if you are alive but incapacitated, which is generally when the financial power of attorney triggers, and your agent, in this case, Jim and Jane, have named each other as a primary agent. So we'll say Jim is ill, and Jane needs to transact something on his behalf, maybe withdraw the IRA, RMD or something for him, or sign his income tax return for him. So she's effectively presenting the financial power of attorney to a third party, right? And they say, oh, it's too old. So technically it's not in the law stale, but we find more and more third party, primarily financial institutions, saying 20 years, that's way too old, updated. And the problem is, if Jim is competent, which he is in our scenario, Jim and Jane both still competent, then it's easy to update. And that's a no-brainer recommendation from Lydia and I, that they absolutely should update the financial power of attorney, in part just so it's not stale. And they don't have that pushback from a third party in case it is actually necessary to use the power of attorney. But the other reason for updating it is things just keep changing. And one of the most recent things that we include now in documents like that is the authority you give your agent to access your digital assets. So, prior to 20 years ago, nobody ever heard of a digital asset. And now with such technology and so many devices, people have multiple devices. If you're alive and incompetent, and also when you're deceased, nobody, generally speaking, can access your digital assets unless there's a specific statute in the state in which you reside. So we find lots of agents under financial powers of attorney having difficulty accessing digital assets, executors having difficulty accessing digital assets. And it could be as simple, my very specific example happened to me. My client didn't have anybody to name, and to this to the point of this particular client, couple as well, Jim and Jane, they don't have a large family. They don't have close relationship with agents or fiduciaries. So I had a gentleman who asked me, I served for him, but my specific point is he dies. I'm his court-appointed executrix, and I need to find people. And the only way I'm going to find people, because he's not keeping a nice paper a trail of his friends and remote relatives or anybody else I might need to find, it's all in the iPhone, right? So I got to get into the contacts in the iPhone. And how do I do that? So you could need a court order to do that if you don't give your executor or agent the authority. So ever so much cheaper to give them the authority than to make them go into a courtroom, spend the money, spend the time to get the authority. So lots of new stuff to include. And if you don't have, what I find sometimes too, as Lydia does, I know in this particular example, Jim names Jane, Jane names Jim, and then they don't have an alternate agent. Very, very important to dig deep and have an alternate agent. So my alternate agent example, I expressed to you as I had 4 different clients, all of whom they had the same scenario as Jim and Jane. They didn't have a deep bench, but they were friends among this group of 4. So they all cross-named each other, right? So it's like Andrea names Lydia, then Lydia names me, then I name Andrea. And they knew each other well, trusted each other, and just as friends, right? So you don't have to have a relative. You can have a friend who you trust to do these jobs for you, both in the financial power of attorney as well as in the healthcare power of attorney. Or sometimes you need to go to a professional. I see lots of folks have long relationships with their accountants. They name their accountant on the financial side as executor or trustee or agent under the financial power of attorney. Sometimes you actually use a professional entity, a bank or trust company. You can use an attorney, you can use a combination. So financial power of attorney, oftentimes we find people naming co-agents that would help each other through the process. So you might have a friend as linked as a co-agent with the professional. So the professional gets all, as Lydia described, what's the best income tax strategy, right? Let's make the charitable gift this year. No, let's not. All those, sell the stock. No, don't sell the stock. The basis is too low. So you've got the professional making those observations and giving that advice. And then the individual who might be, your best friend, your college roommate or something, right? Then that person knows you personally too, and they work together. Also, yes, go ahead,
5
Angie.
minutes. We're at the 5-minute warning to get to the next scenario. So there are a couple of things I just want to make sure we touch on. Lydia, let me go back to you for 1 minute. So can you talk just quickly about how this couple would plan for the second surviving spouse to make sure that when they look at their budget, when one spouse dies, are there things they need to look for, or how they own their property, how something happens so that they can protect the second spouse in that scenario?
Right. Well, thanks. He does have a small pension, which will reduce by 50% at his death. So if he is the second to die, cash flow is pretty much the same. But they have most assets either in joint names or in retirement accounts. So that's one issue. If they are trying to reduce the potential estate taxes, Deb and I might suggest that they take some of their accounts and have them individually owned rather than jointly owned. But you can't do that with retirement accounts. So it does make it a little bit more challenging. If he dies first, then Jane will have a reduction in her income, and it may put a little bit more strain on the portfolio, but there is a life insurance policy. So that will help. It's really trying to figure out if estate taxes are going to be a concern for them, at least on a Rhode Island basis.
And what is the estate tax number in Rhode Island, Deb?
So right now, the Rhode Island exemption is just shy of $1.6 million. And if I could, I piggyback on what Lydia was expressing. They could use a joint trust, to Lydia's point, taxes, right? You would normally separate assets. Jane owns some property, Jim owns some property. So we get an opportunity to use that Rhode Island $1.6 million, we'll call it exemption, when one spouse dies, to defer at the very least any potential estate tax impact. At the federal level, current law, it's over $11 million. Each taxpayer can shelter over $11 million, but each state is different, and Rhode Island's still quite modest, $1.6 million. Massachusetts, even worse, at just $1 million. But if they wanted to focus on each other, and if that's the primary goal, then I also would suggest we would review with them how a joint trust can help them. It helps avoid the probate process, because any asset that's in a trust or designated to go into a trust avoids the probate system, which means when you die, there is no requirement to go into the local probate court with a will and a list of your assets. Trusts are completely private. They avoid any court proceeding 99% of the time. And from a tax planning perspective, as Lydia says, even if they use the joint trust, so they're 100% providing for the survivor, not worrying about taxes at that point, when the survivor dies, then the trust at that point could include whatever charities they want to. So if they're not able during lifetime to sleep at night, I call it a sleep at night test. If they're not able to sleep at night while they're living, and having made too large of a gift, or feeling they might be making too large of a gift, then when they're deceased, they get a whopping $1 for $1 estate tax deduction for any assets bequeathed to charity. So they could protect each other in the joint trust as one option, and completely cut out the estate tax at the death of the survivor by including charity at the second death.
And talking about just charitable, other charitable options, they have a life insurance policy and they have IRAs, right? So at this point, part of the conversation might be that using an IRA, you can use your charitable required or your qualified charitable distribution from your IRA up to $100,000 a year, right, can be directed to charity, and that doesn't count as income. That would be counted directly as a charitable gift. Or using a required minimum distribution if they don't need that money coming in every year. If they have sufficient income and they don't want that to be raised and taxed at a higher, if this puts them over that threshold, they could use that required minimum distribution to give to charity without really realizing any impact on their day-to-day lives. And also they have life insurance. That policy can be gifted to a charity at the end. So at the end of their lives, that policy would be given to whatever charity that they've designated. So in your conversations, I'm assuming those would be some of the things you'd look at and say, you have a mixture of assets that might be better used for charitable gifts than others.
The only caveat there is that the qualified charitable distribution is only available to those 70 and over. So Jim could use it, Jane cannot yet use it, but it is the most tax efficient way. You don't really want to recognize taxable income through your required minimum distribution and then take a charitable deduction. You want to take the income out above the line, so you make the gift directly to a charity with the qualified charitable distribution, but it cannot be used for a donor advised fund. So you really need to talk to your financial professional about these ins and outs on these before you just do it. But there are so many cascading tax effects on your Medicare premiums, certain surcharges, that the whole idea is to keep it out of taxable income.
Exactly right. Now we are at the 6:32 mark. And folks, I don't know if you can get a sense of this, but the three of us love this conversation, and we could throw different facts at each other and change the scenario. And there's so much that we haven't covered yet. So if you have questions, please put them in the Q&A We know we're going fast. We're trying to give you a flavor of a lot of different things. So we're going to move on to another scenario just to, again, address some different concerns that might come up if we change the facts, and we're going to do that. So Lydia, John has come into your office. He's right after Jane and Jim, and he's a little different. He's in his 80s, and he's recently a widower. So let's talk about him and talk about his family a little bit. What I would like to make sure that we cover are some philanthropic concerns for him, and also specifically how he might make decisions on picking an executor, picking a financial power of attorney and healthcare power of attorney, because in our fact pattern, those are gonna be concerns. And I'd like folks to hear how family and friends can play into making those decisions. So if you could start with that, and then again, Deb is part of this loop already, so we'll bring her in a minute.
Yes, John is in his 80s. He and his wife were married for about 60 years. She was an educator, and they had been giving to PC and other educational institutions. This is part of their DNA. His financial situation is solid, but he has a good portion of his net worth in real estate, his primary residence, and a property, a vacation property on the Cape in Massachusetts. So he's starting to feel some cash flow pressure, wondering what he should do with the Massachusetts property. Should he keep it? Should he gift it to the kids? Or should he try to get them to buy it from him because of interest rates being so low? Because if he gifts it, they're going to inherit his cost basis, which is very modest. He only paid $75,000 for this place on the Cape, and he needs to have a buy-in from his children as to whether they really want to make this their family vacation property. If not, then he could just sell it and get rid of the expenses, or just hold it till death and get the step up in basis. He has 3 grown children, and this is what muddies his situation with his estate planning. He has 1 daughter who's married with 3 children. He has another daughter who's a nurse with no children, and he has a son. He's married, son has 2 children. So some have grandchildren, some have given them grandchildren, 1 has not. So they're trying to figure out how to equalize this. He and his wife had always wanted to treat all the grandchildren equally, but now does that, how does that affect the one who doesn't have children? Also, he has a son-in-law who he is pretty sure has an addiction issue. He doesn't have all the details, but he is wary of having too much authority vest in his daughter, where she could be manipulated by her husband. And he does need to have all of his estate documents updated. He's been helping with some tuition payments for the grandchildren. So now he's also wondering if he should be trying to equalize some gifts to his daughter who has no children. For the healthcare powers, he just doesn't know who to pick. I mean, he'd like to maybe have the nurse be involved because she would have that link. And then for the financial power of attorney, maybe she's not the right person. So which of the other children would be the right one to put without saying the son necessarily gets financial decision-making and the daughter gets the caretaking? You get a lot of issues there. They didn't believe in long-term care insurance. So he is vulnerable if he needs custodial care, whether his children will be able to help him with that, whether he'd be able to stay in his home, or whether he'd be forced to sell the house and move into a facility, which could increase his expenses. So his primary dilemma is who to name. It's really, he's going to be fine in terms of his assets. He does have a retirement account. His wife did have a trust. And so there are some assets that went into this trust at her passing, about $400,000 or so, that will go on to his children at his death. He does get income on that trust. So he again would like to make gifts. He's just not sure if he can make anything substantial now. We talked about funding a donor advised fund with a smaller amount now with some of his appreciated securities, and then making a bequest in his will or his trust to go to the donor advised fund at death, and then letting his children be responsible for choosing the recipients. So out of this, you know, Deb and I have worked with other people where a family meeting becomes very important. You decide whether you bring in-laws or you just leave it to your lineal descendants. But, and I've seen people go both ways in that, but this is a situation that's almost begging for a family meeting to talk about some of the things he'd like to do and understand whether his children are on the same page. Because they may be waiting to sell that property on the Cape because they're not using it anymore, or they may not want to keep paying for it. So those are the things. Again, he hasn't updated his documents since his wife died. It's been very difficult for him to do that. And so now he does have those same dilemmas that Jim and Jane did to some degree, except he has relatives. And he just needs to get guidance on who to trust.
So one of his dilemmas, as Lydia explains, you know, time for a family meeting, who's included, and what kind of information is shared, I guess, is the point I'd like to follow in that regard. Sometimes we do family meetings, and the goals are expressed. You know, again, whether it's, you know, are we interested in retaining the Cape Cod house or not? If I, John, should fall ill, you know, do I want to stay in my home? Do I not want to stay in my home? I want you to make renovations to the home so that I can stay in my home. So those kinds of, you know, what are your wishes, right? What does John want now that his wife has predeceased him? What does he want his 2 daughters and son to know that they might not otherwise know, that could be purely personal, right? And familial, but not financial. So some of these family meetings include the actual dollars and cents. You know, my IRA is $3.5 million, right? Nope, I've got an IRA, but I'm not going to tell you how much it is. And there's no right, as Lydia will say, there's no right or wrong. Every family's different. So we always plan ahead. How much information are we going to share? What kind of information are we going to share? And what questions are we not going to answer, or how we work our way around them? So you can have a variety of different types of family meetings. And again, usually we would recommend your advisory team as part of that family meeting as well. So if they had a family meeting with Lydia, that's perfectly fine. But overall, it would be more efficient and probably more effective if they had the family meeting with Lydia and me, and if they've got an accountant, that individual as well. So again, just the whole team concept. A segue into the discussion that I know is important too here. Who do I name in a variety of fiduciary positions? So one of the things that we worry about nowadays, unfortunately, and it's just the reality of the world, so we have to deal with it. If Dad decided he would name just one of the children, in my little example, it doesn't matter which kid he chooses, but he chooses one, whether it's the daughter with the son-in-law he's not sure about, or his son or his other daughter, the nurse. He names one, and maybe that child loses his or her job, maybe due to coronavirus and the virus situation. And so for whatever reason, that child now has a financial burden that he or she and his or her family is facing. So is the child going to be tempted to utilize Dad's money for the child instead of preserving Dad's money for Dad? And so the concept of elder financial abuse, or however you like to term it, is unfortunately top of mind in a lot of different family situations. And a lot of times people will feel, oh gosh, that could never happen in my family. And sometimes it does. Sometimes the child or a grandchild, sometimes you're naming a grandchild, depends who you've chosen, but sometimes that family member is weak maybe, right? And they cross the line. So one way of addressing that, if it's a concern, so maybe John would love to name the daughter who's married to the son-in-law who makes him a little nervous, and maybe there's an addiction issue there, is name that daughter with one of the other children. So there are co-agents. And again, this concept of the two together, co-executors, co-agents, co-fiduciaries, so that dad knows I've got two sets of eyes watching each other, so sort of checks and balances. That's extremely popular as well. Or again, even though he's got the 3 kids, so in our first scenario, Jim and Jane had no children to even choose among, right? This gentleman, John's got 3 kids to choose among, and maybe even some adult grandchildren he can choose among, but he's worried about picking one over the other. Do I prioritize, is the son-in-law addiction really going to potentially be an issue? So maybe he wants to choose an independent person as well. Or again, the independent person and a family member. It depends. And maybe that's a discussion that he would have in more depth with his advisory team, right? And play out the options, the pluses and minuses for him along the road. You also mentioned, Lydia, that he could start with the donor advised fund with something small. I know that he explained to us that that's something he wanted to do in honor of his wife because she was a PC alum. And so he did want to do something in that regard. And then at death, as you said, Lydia, he could more fully fund that. So he starts with something small because he might need, again, a gentleman not having long-term care insurance, he might need his money for himself. Might even need to sell the Cape Cod property just to keep himself in his own primary residence for the rest of his life. So he could be spending down, and he doesn't want to be too generous up front from a philanthropy perspective. So again, at death, he can make that bequest, whether he uses the retirement account, which is usually the best thing to go, the best asset to go to for philanthropy, any which way, whether you're alive or deceased. And then the children would receive the other assets. And I would add, if I may, real quick, I know Andre, we tried to keep the flow going, but on the son-in-law addiction, I will head that way because that was one of the other goals that Lydia raised, the gentleman raised with Lydia, and that needs to be addressed. If he's deceased and his daughter is going to inherit a third, right, of his estate, and he's concerned about the son-in-law's addiction, then he can provide that when he is deceased, the share that this daughter receives is held in a further trust for her benefit, so that son-in-law is prohibited from accessing the funds, and daughter is, full use and enjoyment, and their children also are benefiting. And son-in-law, if he's truly got an addiction problem and he causes a car accident and it's his fault, and he gets sued. He and his wife have exposure issues, right? To Lydia's prior conversation with the prior couple on the excess liability coverage, but at least his wife's inheritance from dad locked up in one of those appropriate trusts for her benefit, then the creditor or claimant could not access that trust share for her. So he can provide his daughter with some asset protection if the son-in-law situation is accurate.
And many parents decide to do that for all their children, to put it in trust, to prevent against the in-law that, could divorce them, could get into trouble, some financial difficulty. So we try not to be sexist in that regard. We're not just here to protect the daughters. We're also here to protect the sons. And I have had situations where only one child had their inheritance put in trust. In this particular case, it was the son, and the daughter got hers outright. And it caused immense friction between the siblings. So when you do that,
Right.
it's always best to just say, I'm doing this. You know, once they get their distributions, they can use it for the family if they want, but principal is going to have to be used for their own needs. And then the goal is to get it to pass to the grandchildren ultimately.
And that applies as well. I agree with Lydia. That applies as well. Again, we're using the scenario of the son-in-law has a potential addiction issue, but if the daughter is a brain surgeon, right? Or the son is an engineer, and there could be malpractice issues, which, you know, come to the forefront in regard to their professions, then the parent, John, in our example, he can protect those kids with this continuing trust as well. So sometimes it's just pure asset protection around everybody, just in case there's a third party event, right? No matter what that third party could be. Sometimes also the continuing trust for the children is a tax strategy, not an income tax strategy, but an estate tax strategy. So if John dies and leaves each of his children end up with $1 million apiece, just for sake of example, and maybe his children already have significant estates of their own. Now they've just taken another $1 million from dad, added it to their own estate tax problem. Whereas if dad had kept their inheritance in a continuing trust, it won't trigger the adverse estate tax impact on the child in his or her own estate. So sometimes it's not just asset protection planning, sometimes it's also estate tax strategy planning as well.
Ladies, we are right on time, and this is great. We have one question right now that I do want to address because I think it's important and a lot of folks are asking. When does somebody consider long-term care insurance? At what age is that is there a right time to do that?
Well, it's certainly shifted. When I first started working with long-term care insurance analysis, generally people would wait until their 60s, mid 60s. But you start to see people get diagnosed for things, particularly women, osteoporosis or some other issues that start to cause policies to be rated and become even more prohibitively expensive than they are. We've seen a lot of changes in long-term care insurance, and they're not anywhere near as generous as they used to be. So now I'd say somebody in their mid 50s, late 50s, before you get pegged with some debilitating disorder, because it's different. Life insurance, if you are diagnosed with something, you're likely to die sooner, and they're fine issuing you that policy. With long-term care and disability insurance, they're looking for the opposite, the things that could impede you and require you to need care. So anybody who has access to the federal government benefits, civil service employees have a very good group long-term care policy. Generally, you're going to see 3 and 5 year benefit periods now. It used to be lifetime. You don't see lifetime offered anymore. Some insurance policies do have living benefit riders that you can tap against. But I would just say don't wait too long. You'll find that once you get into your late 60s, medical reasons become your enemy there. And it doesn't take much to have premiums that just become, ridiculous. So they do get pricey. You need to find also a very stable company. Don't go for the cheapest policy, because those are the companies that tend to go into receivership, or they tend to keep curtailing their benefits or keep raising their premiums. So again, you really need talk to somebody who really works with long-term care carriers, who is a broker for many companies. The agents that I work with will work with many different carriers, so they're not aligned with just one particular product, and they can best represent you in that comparison.
My experience in that regard, I just mentioned quickly an example. It's actually happened to me, an elderly couple, and the husband figured he would die first. So he bought his wife literally a $50 a day long-term care insurance policy, no bells, no whistles, not even the inflation rider. And a year or so ago passed, and he bought her another $50 a day, very simple policy. Several years passed by, he dies. He was right, he dies first, she survives him. She was in good health at the time, but not too long after, she had a series of debilitating strokes. It was very sad. But the long-term care insurance kicked in, and all it was $100 a day. But $100 a day is $3,000 a month. And with her Social Security and with a pension, he had a pension as well, so she had some of that. And with the income from investment portfolio, she was fine in the nursing home for the rest of her life. The principal, the corpus in the investment bucket was never touched, and the son and daughter inherited that. So even a modest amount can suit you from a cost perspective, because as Lydia says, I know the premiums can get pretty hefty. You don't need every bell and whistle. You could have a simpler version and at least add to the cash flow situation if and when it arises for you.
Right.
I'm not seeing any more questions in the question and answer section. So if you have them, we only have a couple of minutes left. See, I told you this would be fun and time would fly. But certainly if you have questions, type them in now. Deb and Lydia, I did have something I wanted to go back to first. I do want to say that as part of the team that you were mentioning, estate planning attorney, insurance folks, or financial planners, your accountant, and also if you're interested at all in philanthropy, whoever you are working with, somebody at the Rhode Island Foundation, the Catholic Foundation, Providence College, someone like me who's a development officer, those people, we are a part of this team as well. It's really important, if you are considering making a charitable gift, to include us in that discussion, because there are ways that we can give you language to put in your will. We can direct you to the things that you're passionate about and tell you what's going on in whatever organization that is, so that at the end of the day, if your gift comes through a bequest, we can honor what you wished for during your lifetime. Or if there's something that you want to do during your lifetime, we also have conversed with the other members of your team to make sure that we can do that without putting you in any peril or affecting your lifestyle. So as part of that team, any kind of conversation that you have with a significant philanthropic gift, please do talk to the development person on the other side of that. We do have one more question. Let's see. Any concerns with the change of administration and the federal exempt tax estate level?
So that's a very good question. It's a very hot topic at the moment. As I mentioned, the current federal exemption is $11,580,000 per taxpayer. A married couple can combine that to over $23 million. And the concern is that it will be decreased, proactively decreased. The way the statute is written currently, it's supposed to sunset, quote unquote, or revert anyway in 2025, basically to half. So somewhere between $5 and $6 million is written into the current law, a reversion. But the concern now is that there will be a reduction, a permanent reduction to even smaller. I have heard back down to the 3.5 million, which is where it was before. It got increased starting in 2010 and 2012, et cetera. So that's definitely discussed. And I have a lot of clients, I'm sure Lydia, you do as well. The wealthier client, particularly concerned about using the $11 million now before December 31st on the philosophy of use it or lose it. So a lot of people, and it's discussed in the media and everywhere, are we going to lose that 11 million? And should I take advantage of that now with lifetime gifts if I'm able financially to do it?
And I've just learned through so many tax law changes over my career that, you shouldn't jump the gun just because you're having a change in the administration, because it takes a long time to get something like that through Congress. And I think we have so many other things on the plate. I would not feel, that my clients had to get this done before year end. Sometimes that ends up with unintended consequences. They don't realize how much control they've given up to get those assets out of their estate. So I do believe we will have time to do thoughtful planning in that regard. And we have this pandemic to address first. We have stimulus to address next. And I think Congress is going to have their hands full for a little while. So estate taxes may not be top of mind for going into 2021. And generally, you do have a little bit of a runway to plan because you get to know when the effective date is. That doesn't make it any easier for Deb, because she might have a short window where everybody's saying, oh, I've got to get this done by that deadline. But when you have clients with significant assets like that, they generally are already starting to create
Correct.
entities like family
Correct.
limited partnerships and LLCs, and ways to start transferring interests to their children and grandchildren. So there are a lot of lifetime gifting opportunities. Some assets are harder to value each year to do that. So it tends to be a little lumpier. You might take one asset and do it all at once because you don't want to pay for valuation every year when you're giving fractional interest. But wealthy families do have a different techniques that they can use to start gifting during their lifetime, including paying tuitions directly, paying medical expenses for family members directly. So many different ways to keep the pressure off. And, just always act on facts, not on rumors. That's my final advice.
And we have time for one last question. At what approximate asset level should one consider a trust?
I'm going to say almost any asset level, depending on your situation. If you're trying to protect assets from children, who are married to people you don't trust, it's a way to avoid probate. And I'm going to let Deb talk to that. But there are many good reasons why you can have either a revocable or an irrevocable trust for privacy concerns primarily, not always asset protection.
No, I agree with Lydia, and the smallest trust I ever helped a lady create was for an elderly lady. She was widowed. She had one child. She was greatly estranged from the child, from her daughter, but she had two grandchildren who she absolutely adored and was very, very close to. They were in their 30s. The grandchildren were in their 30s at the time. And she had, her entire life savings. She did not own her home. She rented, and her entire life savings was $85,000. But she had done her research, and she knew, she's telling me what a trust does, right? And the financial advisor, the investment advisor, she's telling him, no, I know exactly what I want. She knew it would give total privacy, i.e. the daughter would not be entitled to the information, and only the grandchildren. And she chose a cousin as the trustee. She knew that the cousin would do what she wanted and not share the information with the daughter, and provide for the granddaughter and grandson only. And for her, it was $85,000, but it was $85,000 to her. And she didn't want her daughter anywhere near it, not even the information. So, I agree with Lydia. We see many, many, many different scenarios, and people educate themselves on the subject, which is good. They come prepared frequently with already a fair understanding of what their options might be, or at least the basic goals that they know that trust can help them achieve. Andrea, you're on mute.
So I was an English major and I love language and I hate dangling modifiers. So I also hate one little question to be unanswered, and there's only one question left. So we're going to take one more minute. And I think this is a pretty easy one. Is the IRA required minimum distribution going to become mandatory again in 2021? And I think that, so the IRA minimum distribution didn't, that it didn't change that you no longer have to take your required minimum distribution. It was just the age that changed. So instead of 70 and a half, it's now 72, correct?
As long as you
Yes.
were not 70 and a half at that time.
Right.
But
So-
they did suspend the requirement to
Right.
take a required minimum distribution in 2020
This
for
year.
anyone.
Mhm.
And this is only the second time I recall them doing that. They did it also during the financial crisis.
But
So I
that was
wouldn't,
only suspended until December, right? So then it's only, that requirement to take it is only suspended until December. So yes, it's coming back in January, and the age changed, right?
right,
Well,
well,
the age change and the age change is separate, and a totally
Okay.
separate issue, totally separate statute, right? But to Lydia's point, for this year, I think primarily because of the coronavirus situation, right? Congress tried to be helpful and eliminated for at least this year. Of course, they could expand, right, and extend to 2021. We'll have to see what they do. But for now, you do not have to take for 2020 from your RMD.
right. And
And
the
any-
reason they did that was because at the time that the pandemic started to show its effects, the market declined rather precipitously in March. And they knew that to require people to take out a required minimum distribution based on last year's market value could be, could be impairing portfolios when people would have preferred to leave the money invested. And that's the same they did during the financial crisis. It was due to a severe market decline that they didn't want to force out money to people who then you have to base it on the 12/31 value of the prior year. So since the market has recovered, we'd have to see. I mean, if there's a market swoon in 2021, they could do it again. But even during the financial crisis, it was only 1 year. So I would say this year, take it as a gift if you don't need to use the money. Some people still have to take money out of their retirement account just to live on, which is okay. That's what the money was there for. But from a tax perspective, if you're trying to defer it another year, that's great. And for those who weren't subject to RMDs at the time, they got that bonus of now not having to start until they're 72. So win-win.
Ladies, we have hit the 7:05 mark, so I know we've gone a little bit over. I could talk to you both for many hours. Everybody else, thank you so much really for coming tonight. Like I said, this is the first in a series. We have targeted age groups and more life stages than age groups. So the session in January will be focused on questions for folks who are preparing for retirement, not quite in retirement. So your questions that you might have as you're getting ready. All of that information, again, is on the Money Matters site over in Friar Ties. There is a survey that we've set out. It's in the chat at the bottom of your Zoom, and you also should be getting an email with that link as well. If you would please fill out that survey with only good information. No, really, be honest, be open. We'd love that feedback. And again, we really appreciate you coming tonight. Thank you all, and have a wonderful, blessed Thanksgiving. Thank you. Bye, everybody.
Good night, everyone.
Good night. Thank you.